I'm trying to see my son. I've not seen him for a couple of years. I'd get halfway there and she'd be like, no, but he's ill. I don't know what to do.
Stay motivated to having a relationship with your son and do what it takes to find out where she lives.
And my husband got divorced a year before we got married.
Yes.
And we've just realised he didn't do a financial settlement as part of the divorce.
Yes.
I'm just wondering now if his ex-wife could still come after us financially now that we're married.
Could she apply for financial order? Yes, she can.
Would she only be able to come after the things that he had before marrying me?
But now that you're married, your assets are his assets.
Is there any point in actually getting married?
Okay. Welcome everyone to the Legal Queen live show. I am Tracy Maloney, aka the Legal Queen. I am a family law solicitor with over 20 years of experience, and over those years I have helped hundreds of people with not just their divorce cases but their finance cases and child custody matters. So if you think you would benefit from some of my help, then please join me on the Discord. Pop your hand up and I'll get to you as soon as I can. Now on to the first caller. Nathan, I'm going to come to you. Let me just take you off mute. There we go. What is your question?
Hi, basically, I'm trying to see my son. I've not seen him for a couple of years because me and Mum don't get along. But she moved like 3 hours away.
Yeah.
If I ever had the opportunity to go and see him, I'd get halfway there and she'd be like, no, but he's ill. So I'm just basically trying to see how I can have contact with him, but not with Mum. Does that make sense?
It makes perfect sense, Nathan. So have you got a court order in place at the moment?
No, I've
Okay.
never. I don't know what to do.
Okay, so you go onto the government website. I'm going to break it down for you step by step. You go onto the government website and you type in C100. All right, and that's going to give you the form that you need to fill out and send to the court. You're going to send it to the family court nearest to where your son lives. So that's going to be a family court 3 hours away from you. All right.
I don't actually know where he lives now because she just got up and she was just.
So that all right.
I know what she is, but.
So that's job number one. Find out where she is. Just make as many inquiries as you possibly can with family, with friends. Go on social media. Look at her posts if she hasn't blocked you already. Worst case scenario.
Yeah, we have zero contact.
Okay. But Nathan, listen to what I'm telling you. Okay. If you want to have a relationship with your son, you have to make an application on the C100. And if you don't know where she lives, you have to find out where she lives. All right. You can use people like inquiry agents who will help you. Google an inquiry agent. They will cost you 80, 90 quid. You give them your partner's, your ex-partner's full name and date of birth, and they usually will generate something. Just work hard at finding out where she lives. She hasn't gone underground completely. Again, like I said to the last caller, think outside the box. Stay motivated to having a relationship with your son and do what it takes to find out where she lives. It's easier than we think to find out where somebody is. Okay, we've just got to really sit down and think about it. And then once you have that information, you don't even need her address. You can have her email address. You can have a WhatsApp, a phone number. You can serve people in all sorts of different ways, okay? Worst case scenario, you can apply to the court for a disclosure order. And the court can then make inquiries with DWP, Department of Works and Pensions, to find her address. So that's your first job. Get her address or some sort of way that you can serve the application, and then you make the application, okay? That's what you need to do.
Okay.
Brilliant. All right, Nathan.
Yeah.
Thank you. Thank you. Bye-bye.
All right. Bye-bye.
So, guys, you know me. I'm sort of very direct and to the point. For those of you that maybe jumped on halfway through that, I wasn't sort of telling Nathan off or anything of the sort. I was just sort of telling him, right, this is what we need to do. It's very frustrating sometimes when mums won't let dads see their children. And I'm really passionate about that. A child has a right to have a relationship with both parents, not just one. And as long as it's safe to do so, mums shouldn't be preventing dads from having contact with their children. So if you know a mum out there that's doing it, please, please, please don't let all the resentment and the emotional turmoil that happened between you and your ex affect that little boy or that little girl from having a relationship with their father.
Hi, so I'm currently married with a daughter,
Yeah.
and my husband got divorced a year before we got married, and
Yes.
we've just realised he didn't do a financial settlement as part of the divorce.
Yes.
So I'm just wondering now if his ex-wife could still come after us financially now that we're married.
Well, could she apply for a financial order? Yes, she can. Your husband can't, obviously, because he's remarried. And yes, I mean, it depends on her needs and it depends what assets that she has, really, and if she needs to make a claim on your husband. But yes, if there was no financial order arrived at between them both, then he hasn't severed financial ties. Great question, because it's something that I do talk about a lot, and it's not written anywhere, unfortunately. But guys, if you're getting a divorce, please think about getting your financial order as well. So you are a little bit vulnerable there, Kirsty.
So with following on from that with the context is, would she only be able to come after the things that he had before
No,
marrying me? Because I
no.
got more than he ever had, if that makes sense.
But now that you're married, your assets are his assets. Do you see?
Yeah, so
So
could she come after things that he acquired after their divorce?
absolutely. She can now come after any assets that he has. And of course, your assets are now his assets. And look, I'm giving you the worst case scenario. If it ever the matter went to court, the legal team for your husband are going to be arguing that, well, hang on a minute. These guys have only been married a short time and we can't possibly think about taking away the new wife's assets. But the starting point would be, yes, your assets are now his assets and his ex-wife can make a claim against his assets. Absolutely.
Amazing, thank you.
Pleasure. Thank you, Kirsty. It was a great question.
So I've got a couple of questions here for you.
Yep.
In 2018, my husband and his ex-wife separated.
Yep.
They split their assets between them, approximately 65% to the ex-wife and 35% to the husband. As she was a stay-at-home mum and he worked, she convinced him that if it went to court, she would get more, so he did that. In 2020, their divorce was finalised. This was done online with no solicitors. He'd never heard of a clean break. We met in 2021 and married in 2022. His ex-wife now won't sign a clean break order and wants to claim some of his pension and an inheritance she has heard about. They share custody of the children 60-40, so he also pays CMS. He works full-time. She works part-time and claims universal credit. She owns a house outright. My husband and I share a mortgage. What are the correct steps to take for a clean break order? And is it likely she will have a claim to more assets?
So, yes, if money has been divided already, and a lot of times people sell houses and they divide the funds between them, but they don't get the financial order, you haven't severed those financial ties. So what that means is that either one of you can come back and ask for more. So yes, she can come back and ask for more of his pension. And if that's what she's saying, then a clean break order is now out of the window. Because a clean break means that we don't have any assets to divide, or we don't need to divide them anymore because we've already done that. She is entitled to a percentage or a share of all the pension contributions made during the marriage. And if she hasn't had those contributions, she can still claim. So we no longer have a clean break scenario. If we can't agree, the matter has to go to court. That's the only way that we're going to get our financial order. If we can agree and the person is in agreement to dividing his pension, then you don't need to go to court, but you will need a solicitor to draft that order for you and also to advise you on whether the order that's being made is fair and reasonable. The other thing that I would say is that we want to record in the recitals of that order what's already taken place. We don't want to lose sight of the fact that she's already had more than 50% of some of the assets already. So we're going to record that in the order.
And also, just for this scenario, it sounds like the husband in this has remarried, so that's put a bar on him making the financial order, hasn't it? Just for other
Absolutely.
people that are listening.
Yeah, absolutely. He can no longer make an application under the Matrimonial Causes Act, which is the legislation that we use for these orders, because he's not married to that person anymore. So he would now be reliant on his ex, who I hope hasn't remarried, so that she can make the application, or she can instruct a solicitor to. But it is all down to the other person now.
Okay, thanks. Next question, Trace,
Yep.
is when you talk about status quo for children, what do the courts typically look for?
So status quo means routine, essentially. So what routine were the children used to prior to the separation? Or sometimes couples have been separated for a long time, 2, 3, 4 years. What's that routine been like for the children? And the court are going to try to stick to that. So to give you a more detailed example, if we have separated, let's say, and the children live with mum and have alternate weekends with dad, and now all of a sudden dad's going, well, I want to do 50-50 shared care, that's going to be hard because the children are used to living with mum and having alternate weekends with dad. So dad would really have to deliver some compelling evidence to say, court or judge, you need to move away from the status quo. The status quo has been live with mum, alternate weekends with me, but I now want to shift that. So that's what we're talking about. Routine, essentially, is the status quo.
Hiya. I've got three kids altogether.
Yes.
2 of them been fully adopted due to the amount of my ex being very, very toxic.
Yes.
Um, she's managed to have a chance with. So basically, I've got 2 mums. I've got
Yeah.
2 girls with a mum. She's managed to pull a knife to me, etc., and she's still managed to have a chance with my kids, 2 of my kids, my
Yeah.
2 daughters. But I've never actually been given an opportunity to even prove to social services or anyone like that of anything because the amount of lies that she's done to the police. I have tried showing the judge proof that it's all a load of false allegations.
Yeah.
And since then, I've moved on with somebody else. I've moved out of the area. I've had a son. He's currently 1 year old, and he's currently adopted, but he's not been fully adopted. Can we stop that at all?
Oh, that's a great question, Matty. But it would require advice. I mean, obviously, I have no idea of what's gone on to even trigger the adoption process. It's difficult where you've got a toxic ex, borderline narcissistic ex, who you are.
They moved
Yeah,
from one part of the UK, and it was like 3 hours away to give a chance.
yeah,
She was doing really, really well until like relationships thingy. But with the new mum, she's done everything she can. She's put restraining orders on people. She's constantly calling the police saying, this person's threatening to kill our son.
mm,
She's then told her housing and social services that, she doesn't feel safe at that property.
yeah,
And all she gets is, we don't care.
yeah.
And we've tried for 3 years trying to move, and they're saying the only concern that they've got is the property that she's at because of her
Okay,
sister that's tried killing our child.
okay. Um,
But why
Click.
have they not helped her, if you see what I mean?
Yeah, so I definitely wouldn't be able to answer that question, Matty. What I would say though, it's helpful to get advice, and I don't know if you've been getting advice already, because it's all about perception, isn't it? Your perception and your baby's mum's perception will be very different to social services. And sometimes it's helpful when a solicitor can sort of get a real, good idea of the case to be able to say to their client, look, this is what you need to be doing. You might not agree with it, but this is what you need to be doing, because actually your conduct or your words or your actions are giving social services this perception. Because let me tell you that social services will only go for adoption as the last resort. It's not their first port of call. They do not
The
want to be.
adoption paperwork have been done for my son, but he's not been fully adopted.
Yeah,
We're trying to get the property a bit more safer. We've put like CCTV and all that up.
yeah.
Do you think we can try and convince the local authority to reverse that basically? And is there a point where the judge will say, no, adoption's
It's
done.
it
Is that it, or can we prevent that before the
it's
adoption parents are
look,
assigned?
can you try to prevent it? Absolutely, yes, you can. I think what you're actually asking me, Matty, is what are our chances of success? And I can't possibly answer that. I have no clue about your case. But can you try to prevent it? Yes. What concerns me, and I'm going to be absolutely real with you, is that you have a child who is 1 and is already a long way down the adoption process. That concerns me. Because, as I say, social services use adoption as the last resort. How have we moved so quickly in 12 months? That's not a question to you. That's an observation that I'm making.
Yeah.
Do you see
Yeah,
what
because
I
we've
mean?
been on Facebook trying to message people about like mutual exchanges and stuff like that. We're
Great.
on another app as well.
Brilliant.
We've shown them proof,
Yeah.
we've shown the judge, but because the local authority had like social services lied in their statement and the judge had found that they had lied,
Yeah.
the judge has made an order that we get to see our child at least twice a month till
Yeah.
he's 18 because of the amount of lies that's, you know, because the one of the main points was apparently mum wasn't taking care of our son in hospital, but the NHS had actually put a statement in saying that she was putting alarms on, she was always there, not once did she need help. She's latching, she's doing everything that she can, and she's always putting her phone down, if you know what I mean. She's not really taking calls.
Yeah. I'm going to suggest,
And she's
Matty, that
prioritising her son.
I'm going to suggest, Matty, that mum and social services don't have a great relationship. And maybe mum starts to work with, with that, because it doesn't seem rational. What you're saying to me doesn't seem rational, and it's not rational. But I suspect there's something else there, because social services won't be irrational for the sake of it. They are underpaid and overworked. If a child is safe, they're going to move on to another family that need more help. All right. So I would say there is something else, that relationship maybe between mum and social services, that's fractured, and mum's not doing everything to help herself. There's something not quite lining up there, would be my suggestion. But of course, I don't know, because I don't know anything more about your case.
Yeah, that's understandable.
Yeah, but work harder at it. But, you're doing all the right things. NHS have got no concerns. The courts seem to be wanting to give you a little bit more contact. So you're heading in the right direction, but try harder, work harder if you want to overturn that adoption application that social services have made. All right. Captain, you back off mute. How's it I can help?
Is a domestic abuse protection order recorded as conduct on Form E? How can ex's solicitor say it isn't a conduct matter and refuse allegations even though there's an order by the police?
It will depend if the conduct is going to impact the finances. It's not as straightforward. It's absolutely a conduct issue, but is it a conduct issue that we're going to rely upon for a financial settlement? Therein lies the question. So if your solicitor is telling you that it cannot be used as financial conduct, then take their advice. Difficult for me to answer that one without actually knowing a lot more about the case.
I'm going to ask you a question here, Tracy.
Go on.
I know we've talked about it privately, and we see it a lot. Is there any point in actually getting married?
Okay, so I get this a lot, and yes, you and I have spoken about this, Captain, off air. Essentially, you get married because you want to. I think getting married is an emotional decision. It's not a financial one. The consequences of divorce can hit hard financially and emotionally. I'm not made of stone myself, but they can hit hard financially. But when we're making the decision to get married, it's an emotional decision. Generally people aren't sitting down and weighing up the pros and cons of what they're going to lose should the marriage end in divorce. Because if we did go into marriage like that, chances are we wouldn't get married. It's definitely a personal decision.
Thanks, Trace.
Okay. Mart, hello. How are you? Another one of my trusty moderators here.
How are you, Trace?
I'm good, thank you. How are you?
I'm all good. I got a couple of questions for you.
Yeah, far away.
I'll jump straight in. My solicitor told me that I should get back what I paid off for the house, but then it got split 50-50. X said his solicitor said it will just be 50-50. So what I can assume from that is
Yeah.
she's paid in more,
Yeah.
but then it was split 50-50. What
Yeah.
can she do?
Difficult to answer because I don't know if they're married or not married. If they were married, it may be that it didn't matter, because let's say we've got a 20-year marriage, then it won't matter who paid more into the divorce. We're looking at who's going to get what in terms of housing needs, income needs, etc. If they weren't married, then was there some sort of deed of trust entered into? Did they hold it in unequal shares as tenants in common? So I'd need to know a little bit more to be able to answer that. But what she should do, if she feels that it's been unfair, is go and take some advice. Definitely go and get, even if it's just a one-off advice, to tell her what her prospects of success will be if she were to take the matter to court. So that's what she should be doing.
No worries. The next one is, how long do I have to make a TOLATA claim? My ex has already sold the house and I moved out 3 years ago. We were not married and I wasn't on the mortgage.
Well, I think the question should be, can I make a TOLATA claim? Because if you're, and obviously a TOLATA claim for those of listening is the financial application you make when you're not married. But if you weren't on the mortgage, then we would have to establish if you have any legal and beneficial interest to that property. It may be that you don't. If you haven't significantly contributed to that property from a financial element, then you may not have any prospects of success, in which case you're not going to make the application. So again, another one to there would be to get some advice.
Brill. And the last one I got, I know we've covered this loads of times, but it's always good to update people.
Yeah.
If the father is granted a no direct access in a child arrangements order indefinitely,
Yeah.
and the case was then closed,
Yeah.
does he still have PR?
Absolutely. PR, unless the order says that parental responsibility has been removed, that parent will always have parental responsibility. The wording would be that parental responsibility has been removed. And so if that's not in the order, he still has PR. It's a shame that the order concluded with indirect contact forever, because that's difficult. But obviously there's reasons there that the court made that order, but he still has PR.
Brill, that's all I got for you, Trish.
Brill, thank you, Mart. A lot of people worry that the ex has parental responsibility. And whilst that does mean that they share the rights and responsibilities towards that child, what it doesn't mean is that they can ride roughshod over your concerns. So if you are... The reason I wanted to labour this is because I get a lot of emails from moms particularly that say, I am not putting dad on the birth certificate because, or I haven't put dad on the birth certificate because that means he'll have parental responsibility and I will lose control, or he's going to be able to have contact. That's not what it means. That's not what it means at all. There are lots of dads out there with parental responsibility and still not having any contact with their children. So my personal view is that a child should have both of its parents on the birth certificate. I think it's only right that it knows its heritage. So please don't be concerned that just because the other parent has PR, that means you're not going to be able to keep the children safe. You will still be able to do that, okay?
Hi, thank you. I just had a question. I followed you for a while and you've helped me previously.
Yes.
My ex-husband, who's now managed to get contact center contact in the court, he made a full sort of application. Basically, now he's saying he wants to pull out, right? He wants to withdraw from the case. And the court had ordered like final hearing and all of that stuff. But now they want to ask him to do some police disclosures and all of that stuff. But he's now saying he wants to withdraw and he wants to come to an agreement outside. My solicitors are obviously saying that the court is most likely not to accept his withdrawal due to the allegations. But is it a problem if I thought that he could see the children once in the community with another person supervised outside of the contact centre, or is that gonna...
Yeah, I'm not going to be able to answer that question. I'll tell you for why, Rahima, because it's obviously an advice question. It's advice that you need. Go back to your solicitor and speak to them. a generic answer would be along the lines of absolutely. You can always agree outside of the court arena with your ex, so long as it's safe to do so. Okay, because you've mentioned police disclosure and because you've mentioned supervised contact, obviously I don't want you to share those details here with me, but that makes me a little bit dubious as to agreeing anything outside of court. Of course, the other thing is a red flag. He's been asked to provide police disclosure and now all of a sudden he wishes to withdraw his application. So speak to your solicitor about that, but never shy away from agreeing outside of court so long as it's in the children's, it's safe to do so. The other thing I would say is that if you do reach an agreement with him, still have that agreement placed into an order. The matter's before the court anyway, so have that placed into an order, because once you're out of court and the solicitors have all gone home, at least you have that framework should the relationship, the co-parenting relationship, break down again.
Brilliant. Thank you so much.
Pleasure. All the best, Rahima. Bye-bye.
CAFCASS are recommending overnights for a 2-year-old within 6 months when Dad has only had 2 hours contact every Saturday and he lives over 90 miles, 3 hours away. What are your thoughts on this? Because I think it's too fast and a long way away.
It's, again, really difficult questions today because I'm sort of being asked a question without any context at all. CAFCASS recommendations don't always align with the family's idea of what's in the best interest of the children. And all I would say to that is that's because CAFCASS aren't emotionally involved like the parents are. If you feel, however, that the recommendations are too fast, let the court know that, but give examples or supply evidence as to why that's not in the child's best interests. Sometimes, if there's been a large gap in contact, CAFCASS are quite keen, and depending on the children's age as well, to just speed the process up so that the children can get back to having a relationship with Dad. And it might be that the parent is asking the question, it's going too fast for them, but is it actually going too fast for the children? So there's a lot there that I don't know, but if there's any concerns at all, vocalise that to the court.
Any advice or recommendations for completion of a Form E? Are there any tools or free guides available?
No, there are no free tools or free guides available as far as I'm aware. And the reason for that, I'm going to suggest, is because the Form E is very bespoke. So whilst it's a lengthy form of, I think, about 28, 30 pages, not every page will apply to you. So if a page doesn't apply to you, for example, one of the pages are, please list all the companies to which you've been a director for. If you've never been a director, you would simply write NA, non-applicable at the top. So you will just fill out any page that applies to you. The first part will cover assets. The second part will cover debts. The end of it allows you an opportunity to write a narrative. What other contribution have you made? What other things do you want the court to take into account? So you're just going to do it in accordance to your specific case, really. That's about all I can say on that one.
My partner's ex-wife has sold 80% of the assets when he left. She's now coming after him with the little that he's been left, even though she didn't give him any proceeds of the assets that were sold. Would the court take this into consideration when splitting the finances in a final order?
Yes. I mean, they're going to be looking at the current position if they're asked to make a financial order. The risk there is that if she took 90% and spent it, and he invested his 10% wisely and has done well, and she can then show that she is financially destitute, the court are at liberty to help her by taking some of his assets. They have the power to do that. And that's the risk. That's why, as lawyers, we're always saying, please don't separate your finances and, move along and do all of that before you've got that financial order signed by both of you and sealed or stamped by the court. It's really, really important. But yes, I mean, if she's still got her 90%, then of course the court need to be made aware of that. And it may be that her claim falls on deaf ears, you know. I'm just going to answer this really good question on TikTok. Yvonne asks, our house is in my wife's name. Am I entitled to anything? 19 years together, 9 years married. Absolutely, Yvonne. The first thing I would say is the length of your relationship is 19 years. It's not 9, because if you've been living together and then you make a seamless transition into marriage, we're going to count those years that you've lived together. So this is a long marriage a long relationship straight off the bat. Once you are married, it doesn't matter whose name assets are in. They are marital assets and both of you are entitled to a share of them. And it's a question that I love to answer because there are lots of people out there genuinely think it's not in my name and therefore I have no claim to it. If you are married, yes, you do. So thank you, Yvonne, for that question.
Me and my ex separated in January 24, 18-year marriage and a 2-year-old daughter. He moved out to the matrimonial home at separation and has been living with his partner since. I stayed in the FMH. There must be matrimonial home.
Yeah.
And I'm still there now. We've just had a first mediation session and I found out that he's brought himself a new house before we've agreed anything financial in the financial settlement.
Yeah.
We haven't agreed housing needs yet, and what he has bought is above what we could both afford out of the pot. This will leave me with much smaller house and also has maxed the mortgage, and it means now we can't afford a spousal maintenance.
Yeah.
And is going to cause me serious financial hardship.
Yeah.
Are there any suggestions on what can you suggest as a remedy in mediation based on what the court would do? Would he be penalised by the court for the actions he has taken, which doesn't result in a fair outcome for me?
So no, he's not going to be penalised for buying a property, but please know that if you're not yet divorced, that new property is now a matrimonial asset, okay? So everything gets put on the table. Now, let's say that he's taken all of the savings to put down on a deposit of the house. The court has the power to order that he sell that house. Okay, unless we have other assets that will satisfy the housing needs of the person asking the question, any children involved, the court does have the power that he sell that. So one party can't go taking everything, you know, downloading lump sums from the pension, taking all the savings, buying a property and then going, right, well, I'm sorted. Now you sort yourself out. But there will be no other penalty other than an order for sale. But she has to realise that it's still a matrimonial asset and it will still be included in the assets as we're looking to divide them all.
It's in regards to obtaining a passport, basically.
Yep.
So she says that she had a restraining order against the father, no contact with me whatsoever. He does see my daughter, but I don't want him to stop us going away on holiday.
Yeah.
I don't know how I can get a passport without him knowing because of getting his consent. But I thought they only needed one parent to get a consent for a passport now.
And I think you're absolutely right, Mart. I'm going to preface my answer by saying, please check with the passport office. I'm assuming this is for a UK passport. It might not be. So please check with the passport office first. But my understanding is that you only need one signature if you're applying for your child's passport. So only one of the parents have to complete and sign the forms. And you just give as much information as you can about the other parent. And I think one of the reasons, and Karen is better to answer this question, but one of the reasons only one signature is needed is because you've got lots of family units where one of the parents has just disappeared off the face of the earth. And that would be really sad if the other parent could never take the child on holiday because they couldn't get a passport. But I do think you have to give as much information about the other parent as you possibly can.
Just to reiterate a little bit on that question.
Yeah.
So can you just explain that she doesn't really need the other parent's permission to take the child away on holiday? Is it for 28 days or 30 days?
Well, that depends, Mart. So if you have a court order in place, usually the main carer or the resident parent, or, you know, depending on how your order is worded, can go on holiday for up to 28 days without the other parent's permission. Okay. But that answer causes confusion, because then I get lots of people emailing me saying, well, I haven't seen my ex for 5 years, so how am I ever going to get his consent? But if you haven't seen him for 5 years, he's unlikely, A, to know that you're going on holiday in the first place, and B, to be able to stop you from going on holiday, because he's not going to know, is he? So then I say, check the country that you're going on holiday to, because a lot of countries, they don't want the father's permission or the other parent's permission. They'll just let you through at passport control. Some countries do. Canada, I know. If you're traveling alone as a single parent, they do ask questions about, well, where's the other parent? Do you have their permission to travel, etc.? So yeah, it's one of those anomaly questions that I kind of have to give a bit of a longer answer to, depending on the scenario.
And the last one I got for you, and it's a pretty easy one for you. I have a 2-year-old and dad lives 3 hours away. Would you recommend overnight stays at their age, given the logistics? She's never lived with her, and he's 3 hours away.
Yeah, I mean, again, I don't know the family dynamics. It's not unusual for a 2-year-old to have overnight stays with the dad. And we're not talking about living with dad, because part of the question was the child's never lived with this parent. That doesn't really matter, because we're just talking about an overnight stay. In the same way as, would you let the child stay overnight with grandparents because you were out for the weekend, or you wanted, you were on a course at work or something? It probably wouldn't cross your mind. Absolutely, I'm going to, let my mom look after the children this evening. So why not the other parent? I think it does depend on the family dynamic. As long as it's safe to do so, then yeah, I don't see. Age has nothing to do with it. It's not the fact that the child's 2 or 1 or 15. If it's safe to do so and it's the other parent, then I would say yes.
Brill, that's all I got for you, Tris. Thank you very much.
I've had a lot of questions today from people saying, well, it's dads mainly. Why do the courts only give other parents every other weekend rather than every weekend?
It's a great question. And it's because typically the parent that's in charge of the children Monday to Friday gets all the tedious routine tasks. They're getting them up for school, getting their breakfast, getting them dressed, doing the school run. They're picking them up. They're doing the after school clubs. They're doing the bedtime routine and the homework routine. And they're not actually having some downtime. So if we gave the other parent every single weekend, we'd have one parent that gets all the fun time and the downtime and the chill time, and the other parent who's just responsible for all the chores and has got that mental load. And that's just not fair. So what the court tried to do is give both parents a shot at a weekend so that we can just have some downtime, no routine, everyone's chill, we can go off and do activities or whatever. So that's the rationale behind it, if I'm honest.
Yeah. Marriage of 2 years, relationship 8 years, lived together for 6 years. The family home was bought in the 12 months before the marriage using a large deposit from my property, no contributions made by my ex. House is held as tenants in common, 65% me, 35%. They've put me, but I presume they mean the other party.
Yeah.
What is the likelihood of me being able to protect my deposit share of the home? Children are living with me, weekends with dad.
So it's a 6-year relationship because that's how long they've been living together. So we're just over the short and into the midterm. Your tenants in common is going to help. However, what's really going to help is the fact that the children live with you. So that is the biggest pull away from 50-50 in any event. So I would be suggesting that if this marriage goes through the divorce route and we end up sorting out a financial order, that actually she's probably going to get her 65% anyway, possibly more. I don't know how old the children are. I don't know what her income is, etc., etc. Obviously, as those children get older, then there's less of a pull away from the 50-50.
Yeah. And this is just me being curious, Tracy.
Yeah.
When you get married, can you still hold properties as tenants in common, or
Yeah.
is it different once you become married?
No, when you get married, you can still hold properties as tenants in common. However, if the divorce ends up going before the judge has the power to move away from that. If it feels that the tenants in common arrangement will produce an unfair outcome, absolutely, it has the power to say, I'm going to dismiss the tenants in common and I'm going to decide that this is the appropriate order to make. But yes, you can still hold it as tenants in common, absolutely.
Okay, thanks, Trace.
Lovely, thank you.